Imagine being a tenant facing an eviction hearing tomorrow morning. You have children to take care of, you cannot afford a lawyer, and the court website feels like a maze. This is not an exceptional situation. It is the everyday reality for people trying to navigate the justice system without help. It is also the starting point for IAALS, the Institute for the Advancement of the American Legal System, an organization dedicated to redesigning the justice system so that it functions for ordinary people, not just for legal professionals. Today, I will be taking you through IAALS's reforms and how they have created new pathways to affordable and innovative legal services while maintaining strong consumer protections. With proper adaptation, these reforms could address Canada's most persistent justice gaps. So what is the IAALS? IAALS functions as a justice system innovation lab based at the University of Denver. The organization studies the major failures of modern legal systems, such as high costs, complex procedures, long delays, and it then designs solutions, tests them through pilot projects in real jurisdictions, collects evidence, and uses that evidence to build models that courts and regulators can adopt. Their focus is always on real people's experiences with the justice system, not just lawyers' perspective. The IAALS exists for 4 main reasons. Most people with everyday legal problems cannot afford a lawyer and never receive meaningful advice. Court procedures are confusing, slow, and hard to navigate without representation. Traditional regulation protects the lawyer monopoly, which limits new service models. And lastly, IAALS has a focus on coordinated reform. The Community and Cooperation Report emphasizes this belief that reform succeeds only when it is collaborative. The IAALS brings together judges, regulators, lawyers, technologists, and academics to share data, coordinate policies, and build reform movements that extend beyond isolated pilot projects. Their above-the-line network reflects this approach by connecting reform leaders across states to create a national conversation about justice innovation. When we think about Canadian justice reform, IAALS's approach is powerful because it converts broad ideas into practical, evidence-based systems that other jurisdictions can implement. Unlocking Legal Regulation, or ULR, is IAALS's core project for redesigning the regulatory foundations of legal services. ULR starts by observing that traditional regulation focuses heavily on protecting the lawyer monopoly. In many jurisdictions, only lawyers can offer legal advice and only lawyers can own legal service businesses. This restricts innovation, inflates costs, and leaves most people unable to afford help. ULR's solution is to create legal regulatory sandboxes that allow new service providers and new types of legal businesses to operate in controlled environments. Utah is a leading example. Within its sandbox, companies can test new services, for instance, software-driven document tools, non-lawyer professionals providing limited legal guidance, or law firms partnering with social workers or financial advisors, so long as they submit data and agree to close monitoring. According to IAALS's ULR Lessons Learned report, the results have been remarkably positive. Consumer complaints in the Utah sandbox remain extremely low, and there is no evidence of increased risk compared to traditional legal services. The sandbox success comes from its evidence-based, risk-focused oversight, which tracks performance in real time rather than relying on assumptions about who should be allowed to help. For Canada, where provinces have only begun experimenting with regulatory sandboxes on a small scale, ULR provides a tested model for safe, supervised innovation that can expand access while maintaining rigorous consumer protection. While ULR focuses on regulatory structures, the Allied Legal Professional Project focuses on the workforce. IAALS developed this project in response to a clear empirical reality. Most legal problems do not require a full lawyer to resolve, yet no other professional category is authorized to fill the gap. ALPs are trained and licensed paraprofessionals who can independently handle specific legal tasks. The ALP National Framework lays out the training requirements, competencies, licensing examinations, and supervision structures needed to ensure quality. These professionals function similarly to nurse practitioners in healthcare. They are not substitutes for lawyers in every situation, but they are highly capable in routine, high-need areas such as family law, housing issues, debt collection, and administrative appeals. States like Utah and Arizona already allow ALPs to advise clients, file court documents, and represent parties in specific matters. IAALS's research shows that ALPs often spend more time with clients, explain processes more clearly, and maintain exceptionally low complaint rates. This makes them an effective, lower-cost option for people who cannot afford traditional representation. For Canada, where family, immigration, and tenancy matters overwhelm courts and legal aid systems, ALPs could meaningfully expand the availability of affordable legal help. Ontario and British Columbia have taken limited steps toward licensing paraprofessionals, but without consistency or national standards. The IAALS's framework could provide that structure. IAALS's work extends beyond who can give legal help. They also focus on improving how courts function, recognizing that even with more providers, people will still struggle if court processes are slow, expensive, and confusing. One major example is the Efficiency in Motion project, which examines summary judgment procedures. IAALS found that inconsistent judicial practices and complex evidentiary rules often make summary judgment inaccessible. Their recommendations, clear guidance, more predictable standards, and simplified evidence requirements aim to make the process more usable for both lawyers and self-represented litigants. This is extremely relevant to Canada, where motion practice is similarly technical and costly. Another core project is a Family Justice Initiative, which addresses the realities of family law. The FJI report, which includes 13 principles for family justice reform, emphasizes that adversarial processes often harm children and escalate conflict. The report recommends triaging family cases into appropriate pathways, a streamlined pathway for uncontested matters, a tailored service pathways for cases that require mediation or support services, and a judicial pathway for high conflict or complex cases. These recommendations align with empirical research showing that tailored interventions reduce delays and reduce conflict and create better long-term outcomes for families. IAALS's work also highlights the importance of trauma-informed court processes, recognizing that many participants experience stress, violence, or instability. Courts that understand trauma are better equipped to provide safe and meaningful access. These reforms are especially relevant for Canada, where family courts face long delays, high rates of self-representation, and limited support for vulnerable litigants. When asked the question whether these reforms would challenge or harm consumer protection, the IAALS team said the answer was both yes and no. This nuance reflects their balanced approach. Innovation introduces new forms of risk because new providers and technology may vary in quality. However, the IAALS data consistently shows that risk can be effectively managed through structured oversight. Sandboxes track services in real time, ALPs are licensed through competency-based frameworks, process reforms reduce confusion and error. And IAALS's model ultimately strengthens consumer protection by making oversight more proactive, transparent, and data-driven than traditional systems that respond to complaints only after harm occurs. Canada faces many of the challenges that motivated IAALS's work: unaffordable legal services, shortages of practitioners in key areas, long delays in family courts, inconsistent access in rural and Indigenous communities, and fragmented provincial regulatory structures. IAALS offers a blueprint for addressing these issues. ULR provides a framework for safe innovation through regulatory sandboxes. ALPs give Canada a tested model for building a new legal workforce. Efficiency in Motion and the Family Justice Initiative offer concrete strategies for simplifying motions and triaging family cases. The Above the Line Network and the Community and Cooperation Report show how coordination and shared learning accelerate reform. The value of IAALS's work lies in its evidence. It demonstrates that new models of legal regulation and service delivery can increase access and affordability without compromising consumer protection. Canada can adapt these evidence-based reforms to build a justice system that is more accessible, more efficient, and more responsive to the people who rely on it.